Good morning, good morning, good morning. So we have some slides for you. We're having some technical things. So they're actually being sent around to you via email. So you can follow along that way, or you can just listen to me talk. That's fine too. And I'm glad to be with you today. If you've never heard me speak or seen me speak, I'm very much about the facts and just, getting the information out there. And also about just trying to say it in a way that makes sense to everybody, okay? So we'll have time afterwards, as you think of questions, write them down, and we'll have time afterwards where we can talk through some of those things. So I'm glad to be with you here today, and I just want to offer a quick disclaimer that this, in any kind of multi-brokerage conversation, we can't have any discussion about commissions, meaning commission rates, anything that you might charge to a buyer or a seller. It's prohibited by federal antitrust law. So if you do ask a question or have conversations with each other, just please make sure you do not include amounts, okay? So, if as an example, you could say, if I charge the seller this, you just say this, right? Don't use an actual amount, okay? And thank you for that. And just please remember that all commissions are negotiable in the state of New Jersey. So it's important to remember that, and we'll talk through some of that today. I'm going to talk to you about the New Jersey Consumer Protection Enhancement Act, or CPEA, which went into effect August 1st. So hopefully you've heard about that and you've been practicing that. It encompassed most of the NAR settlement that went into effect on Saturday. So the good news is that in New Jersey, we've sort of been practicing it already. We had a 2-week head start before we needed to, for the rest of the country, really needed to get involved. One of the questions you might have about the NAR settlement is, why did NAR settle? Why is there a settlement? Why didn't we fight this, right? Why didn't NAR fight this? And that was my question too. And I will offer the disclaimer that I'm currently on NAR's board of directors. I'm one of their board of directors. And the board of directors didn't actually make that decision. Okay, that was done at a leadership level because of the way the bylaws are written. And that was a question we all had. Why? The ruling was not right. We should be fighting this. The reason, as it was explained to me, the reason the settlement happened was because fighting it would continue to incur millions and millions and millions of legal fees, right? I mean, in the end, who really won here? The attorneys, right? in any kind of class action lawsuit, it is typically the attorneys. So the attorneys are the ones who won. And that's fine. That's their job. But the NAR settlement actually includes provisions which protect us as realtors moving forward. So as long as we're following these new settlement terms, according to the settlement, we can't be involved in a suit like this in the future. So it further protects us, and that's really important, right? And so that's why it's important that you, your brokers, your clients understand how all of this works, so that you don't get yourself involved or put yourself, your client, or even your brokerage in another, situation like this, okay? So that's why the settlement happened, and it was for a good reason. So do know it was the right decision. Unfortunately, we were involved in that mess, but it was actually the right decision. In the slides, when you received them, I put a quote in there from Jack Canfield, who's a motivational speaker. You may have heard of him. And it says, this is what I have to do now, by the way. It says, change is inevitable in life. You can either resist it and potentially get run over by it, or you can choose to cooperate with it, adapt to it, and learn how to benefit from it. When you embrace change, you will begin to see it as an opportunity for growth, right? And it doesn't matter what the quote is about change. It's always the same thing, right? Change can either be for the good or for the bad. It's how you embrace it, how you adopt it. And this will be good for our industry, okay? It will be good for our industry. But many realtors, well, most realtors, are salespeople, right? And all realtors are humans. We don't like change, right? We don't like change. It's why some of you don't change brokerages, because you are in your comfort zone and you don't want to move to a new brokerage because now I need to get new signs, and I've got to change the address, and I've got to let everybody know, and I might have to change my email. But is that situation still good for you, right? So change is actually a good thing, right? Change can be a very good thing, all right? One of the, when EXP Realty very publicly, we have a big mouth. Kind of like I have a big mouth, the company has a big mouth, and that's a good thing. But we have a big mouth, and so when one of the things that we very publicly said was that EXP Realty moving forward is not participating in broker-to-broker cooperation, okay? So if you haven't heard that, you're hearing it, okay? Is not participating in broker-to-broker cooperation. The immediate reaction, EXP is not working with other brokers. No, that's not what we said. That means you don't understand the difference between the word cooperation and compensation, okay? Cooperation is allowing brokers, other brokers, to bring their buyers to your listing, right? To bring the buyer to sell the listing. That's what cooperation is about. It's in our NAR Code of Ethics, and it's in our New Jersey state law, that we're actually required to cooperate, okay? Unless otherwise directed by the seller. And that means an office exclusive, okay? An office exclusive where you have a waiver of broker cooperation and the seller or landlord has directed you not to allow other brokers to sell or lease that listing, okay? That's office exclusive. That's the only place where we would not be cooperating with other brokers. And the same is true for anyone in any brokerage. It's at the direction of the seller or the landlord. Compensation is about the sharing of a commission, okay? A standard, no, I don't want to use the word standard. Brokerage, many brokerage policies and some reference in our state law, actually, which still exists, say that many listing brokers cooperate and compensate selling brokers, right? And there's an offer of compensation where we agree with the seller as a listing broker for a listing fee, but that listing fee includes an amount that we're going to share with a cooperating broker, whoever brings the buyer, right? And until recently, that figure was in the multiple listing service, right? And so as a buyer's agent or buyer's broker, you saw, how much I was going to get paid, right? To sell this listing. Those who have been with EXP Realty for a long time or have heard me speak before know that I've been a big proponent of buyer agency agreements and tenant agency agreements. It has never been state law until now. But I've always been a proponent of that because you want to have, we're working as professionals, right? You go to an attorney, they have you sign an agreement. You go to a doctor, they have you sign 400 agreements. You go to a professional and there is an agreement with that professional, right? So when we're working in a professional capacity, we should have always had an agreement with a client, always. Well, now we have to, okay? So now we have to. So when it comes to, these cooperation versus compensation, it is important to know, and I've heard from many brokerages that they are also doing the same, or, it may come down the road where they're not participating in broker-to-broker compensation in the same way. And the reason for this is because of information from the Department of Justice. The United States Department of Justice has had a very keen interest in this whole situation. And they have already given advice to say there should be no sharing of commissions at all. So as a brokerage, we said, we're going to follow that advice, right? We're a national company, we're really a global company. But as far as the United States is concerned, we're going to follow that advice. So we want to make sure we're doing everything the right way, starting now, right? So that if something happens down the line, when other brokerages are doing that sharing of commission and the DOJ comes down, we can say, well, we haven't been doing it. It's our policy, so talk to the other brokers, right? So that's a message maybe to bring back to your broker, right? The Department of Justice is really interested in what's going on here. So that's a good message to bring back. But do know, if we have a listing for sale or for rent, unless it's an office exclusive, all brokers are welcome, absolutely welcome, to bring their clients. Word of caution I'm going to give you is that there's a lot of misinformation being shared by experts. In the age of social media and YouTube and all of these other, platforms, it's very easy to jump on, create a video, create a post, and that's fine, as long as you are giving the right information. If you're not giving the right information, then you're spreading misinformation, which is only going to cause more confusion around the real estate industry and is also going to cause confusion for clients, right? So you want to make sure when you're sharing information that you are sharing the accurate information when it comes to this whole situation, okay? And remember, with the NAR settlement, we as a state are already 2 weeks into it because of the Consumer Protection Enhancement Act. So some of the things I'm going to talk to you now are sort of a combination of everything, because it's going to include things from state law, and it's also going to include things from the NAR settlement. This is mostly about how to practice real estate in New Jersey. If you have a real estate license, these are the rules that we all have to follow, okay? So the first section is called Working with Sellers and Landlords. And by the way, one of the there's two funny things to me when it came to all of these changes. One, how things related to MLS listing fees, and we're going to talk about that, but also how it affected rentals. This is not the NAR settlement necessarily talking, this is New Jersey law talking about how this whole thing affected rentals. So everything that I'm going to talk about, when I'm talking about sellers, it also includes landlords. When I'm talking about buyers, it mostly includes tenants, except with the exception of concessions, right, for mortgage loan. So let's go through these, and if you have the slides, you can follow along. So first of all, the very first thing is that, and one thing that hasn't changed, but I always like to include it in my presentations, a listing agreement is required to advertise, promote, or discuss any property in search of a buyer. This is not a new thing. So some of the examples that you might have, you might go to a property owner and they say, well, I'm not interested in listing my house for sale, but go get me a buyer. If you bring me a buyer, then then we can work something out. Here's the thing. You can't advertise and go in search of a buyer without a written listing agreement. Did you know that? Right? You can't. So that either means an exclusive right to sell or exclusive agency, or it might mean an open listing, right? Where you're not the exclusive agent for that seller. Okay? You had a question?
Yeah. I just got a letter last night from them.
Yeah.
From an agent.
Right?
Saying I have a buyer, I want to buy your house.
That's different.
Okay.
So that's okay, because that's prospecting for properties.
Okay.
So you're working on behalf of the buyer, which is good. That's a good thing. As long as it was compliant, that's a good thing. If it was EXP Realty, send it to me, I'll look at it. But it's, yes, it absolutely is. You can work, and we'll talk about that in a minute, but you can work on behalf of a buyer in search of a property, okay? But when you encounter someone who doesn't want to list a property and says, just bring me a buyer, right? For sale by owner might be another example. You know, I don't want to list, but just bring me a buyer. Well, you can, if you're working with buyers now, and those buyers meet the criteria of that property, you can then say, hey, I know of a property that may interest you. That's the difference. If you're going in search of a buyer, email lists, Facebook groups, you know, social media of any kind, you need a written listing agreement in order to advertise that property, okay? Who's ever heard the phrase off-market listings? Do you know there's no such thing? If you're with EXP Realty, you do, because I say it all the time. There's no such thing as an off-market listing. It's used incorrectly. A property can't both be off-market and a listing at the same time, okay? When you tell me off-market listing, you're telling me you don't have a listing agreement. That's what you're telling me. There's no such thing as an off-market listing. You might mean off MLS. That's different. Any property for sale is on the market. So try to take off-market listing out of your vocabulary. So some other changes when it comes to sellers and landlords. Any references to compensation are now prohibited in the MLS. This is New Jersey state law says if it's prohibited if prohibited by the MLS service. The NAR settlement says it's prohibited. So every one of our MLSs in New Jersey, and I didn't mention this, it's in the slide, but I didn't mention, you know, as part of our company, I'm a member of all 13 realtor associations in the state of New Jersey, and I'm a member of all 8 MLSs. So I know their policies fairly well. And so every single one of those MLSs removed compensation from their, you know, from the MLS. There can't be references to it. One of the things you don't want to do is try to find workarounds and loopholes. And I've seen some of the memes, you know, that have gone around where, you know, and I'm not mentioning a number, but there's been a number and a percentage sign mowed into the lawn with an aerial, you know, an aerial shot. Clever, but it can't go in an MLS photo, right? Because that's the sharing of compensation. You can't do it in any way when it comes to using the MLS or a product that's supported by the MLS, which includes things like showing time, right? Includes things like your website if it receives listing information from the MLS, right? And there's actually some confusion on that because they said you can't have it in an IDX, I think it said something like IDX enabled website, which means that probably nowhere on that website you can have it because the website is IDX enabled. So that's one thing that's good to follow up on. Compensation is negotiated now as the listing broker, right? So when you are negotiating compensation with the seller or the landlord, it's for your service as a listing agent, right? That's it. It's your service as a listing agent. I talked about the Department of Justice already. I will say that both the NAR settlement, or I should say neither the NAR settlement nor New Jersey state law prohibit the sharing of commissions from a listing broker to a buyer broker. But it is a bad idea, okay? So the listing broker should be establishing a commission amount specifically for their work as a listing agent. And then talk to the seller about how the process works. When an offer is received, it may include a request for compensation from the buyer to compensate their broker, okay? I agree it shouldn't be a concession, okay? The concession means that it is money being paid as a credit to the buyer, and then the buyer is going to pay their broker, right? Because it now becomes part of their closing costs. Well, fine, but if you need those concessions for other things, that's going to be a problem. So the seller can compensate the buyer broker directly, okay? There are some who are still having conversations with sellers and setting specific amounts. One of the pieces of guidance we've given is, instead of the seller setting a specific amount, to have a general idea of, what their net proceeds need to be. And then, when the offer is received, in the offer itself will be the request from the buyer to compensate their buyer's broker. And all of our agreements are going to be different, right? There is no standard commissions. There are no set commissions. Buyer brokers do not get paid this or this or this only. It is the agreement that you have between the broker, between you and the buyer. And, of course, any information and guidance that comes from your broker. Remember, the relationship is, and I'm jumping into buyers now, I've got to get away from that, but the relationship is, the client relationship is between the consumer and the broker. You are an agent of the broker, acting on behalf of the broker. The broker sets the rules, so make sure you're always following their guidance. That's New Jersey law. You have to follow the supervision of your broker. When it comes to compensation, it must be exact. We can't use phrases like up to or no more than. There's a specific word that they use in the settlement. I don't remember what it is, but it doesn't matter. We don't need big words. We can't use phrases like that. It has to be exact. It has to be, for this, you pay this. Okay? For this, you pay this. Not no more than. Okay? Also, some MLSs have included fields for concessions. Some of them are yes or no checkboxes. Some of them are yes or no checkboxes and a field to fill in. Some of them are just the field. Okay? I can't tell you what to do if you don't work for us, but I can just give you general guidance. Don't fill in the concession field, okay? Because you can't make reference to compensation there. All you can say is seller is willing to offer concessions. But as it was pointed out, the compensation doesn't necessarily need to be paid as a concession, right? That's a workaround. It's not smart. Okay, so that can be empty, right? The one thing that's going to change now is that you all are going to have to talk to each other. You're going to have to call each other on the phone or send text messages and ask questions, right? Because there's no longer going to be a reference in the MLS, okay? We'll talk about how to do that. MLS fees have been a little bit of a controversy because when sharing compensation, some listing brokers have, and I always say listing brokers to encompass all of the agents as well, so just know that I'm also talking about you. Some listing brokers will have in the MLS that there's compensation to a buyer broker, it's this amount minus this amount, okay? I don't know if you all know the history of even how that started. But I've got to tell you, that's just passing off costs. When I got into the industry 1,000 years ago, my brokerage would give, they would say, well, this is the fee you have to charge, this is the fee amount you have to share, and then you have to deduct this specific amount to recover the listing fee that's charged by the MLS. Do you know that not all MLSs charge listing fees? Do you know that? So there are some MLSs where there are, or there were anyway, compensation for a buyer broker less a listing fee. Do you know the average listing fee? Garden State MLS, I think, is $25 or $30. New Jersey MLS might be $40. Don't quote me on these numbers. Hudson County MLS may be $45 or $50. Have you seen the minus numbers that previously, right? So instead of them being these MLS, recovering these MLS listing fees, now we're passing the cost off for transaction coordinators or assistants or marketing or other things. That's your listing fee. Whatever your listing fee, whatever the commission or compensation you agreed to with the seller, that gets covered in all of that. So charge the seller to include your costs. Because if the compensation is now coming from the seller, does it make sense for a seller to offer a compensation minus a listing fee? Does that make sense? Everybody's quiet because they know that, that whatever is being charged there, we're thinking about this now, right? So when you are thinking about your compensation with the seller or the landlord, that should include any and all of your costs. Whatever you need to pay comes out of that. It does not make sense for a seller to offer compensation less some kind of transaction fee or enormous admin fee or whatever it is. Because it's not the seller charging it, is it? No, right? So that's the controversy about the MLS listing fees. So just keep that in mind. There's no official guidance on that, either from the state or from NAR, but I expect something to come from that. Because logically, I just want you to think about it from a common sense perspective. It doesn't make sense, right? It doesn't make sense. One of the things that we're required to do now at all open houses, this includes rentals, all open houses, we must have a sign. It's a really big sign. New Jersey Realtors created one for you. I believe they may have created one only for buyers. But the New Jersey law also applies to renters, right? So our brokerage created a sign for buyers because sometimes you do open houses for rentals, and it's a great idea, especially a luxury rental, right? You have to have that sign at the open house, okay? So make sure you have a sign. If you're doing a rental open house, make sure you have a sign, and get it from your broker, please. One of the things that, one of the catchphrases I use on a regular basis is, everything you do in real estate is on behalf of your broker and brokerage. If you have a real estate license, you are acting on that broker's behalf no matter what you're doing. So if you've created your own forms or your own signs or your own, please make sure you've cleared them with your broker, right? Because if they're not compliant or not appropriate for the business, you could cause an issue for yourself and the broker. So make sure you're not creating your own things. Every brokerage should have all the materials that are needed to do the work that you need to do. Some better than others. But you should have all the materials that you need to do that work. So do make sure you have that sign. And this is New Jersey law. If this is the open house sign-in sheet, then the sign just needs to be right next to it. It doesn't need to be a giant sign. It doesn't need to be on the door and backlit, and it's just a piece of paper. It's just 8.5 by 11 landscape, just sits there. Well, that's our version. New Jersey Realtors created a portrait version, and that's fine to use if you're with EXP Realty. I would prefer that you use the version that we created because it's better. Now, we also have to have a seller's disclosure completed by all sellers, okay? That's been optional over the years. In March, there was a requirement for flood. We had sellers now and landlords, some landlords, had to provide knowledge about flood, and they had to look it up, right? They had to go online and look up whether, the property was in a flood zone. Now, the entire seller's disclosure is required. Questions that have been asked, well, what about REOs? What about them? What about short sales? What about them? What about estate sales? What about them? If the property is for sale, whoever is responsible for selling that property must complete the seller's disclosure. And there are plenty of things on there that are unknown. I don't know. I don't know. Well, if you don't know, say you don't know. You know, whenever I took a listing, going back 1,000 years, keep in mind. Whenever I took a listing, or prior, even at my first listing appointment, I always brought the seller's property disclosure. And I said, you're likely going to have to fill this out no matter who you list with. You might as well get started, right? And then I would pick it up from there. Okay? I rarely had a seller say, oh, I don't want to fill this out. This is 8 pages, right? Most of the best way to say this, most of the way clients react with us or do what they're supposed to do or not what they're supposed to do is based on our reaction. So here's the difference. Here's the seller's property disclosure. You are required as a seller to disclose all the knowledge you have about this property. This is an organized way to do it. Get started, right? Versus, I don't really want to give this to you. But, right? So, you know, it's all in how we do it, right? One of the best pieces of advice I can give you is everything we have to start doing now, do it like we've always had to do it, right? Because I spoke with one of my agents yesterday, and we were talking about this, and you know, there was conversation about, you know, I'm trying to help them understand what has changed. And my response was, why? Did they ask? No, right? So you go to, you know, you always went to a listing appointment and said, you know, here's the process, here's what we need to do, and that's it. We're going to do the same thing now. We're just going to do it with new paperwork. Or we're going to do it in a different way with a new process. This is still new to the seller. Unless they're an investor who you've been working with years over year after year. Most people are not selling properties every year, every few months. This is going to be, I mean, you just bring it to them and say, this is the process. They say, okay, that's it. You don't have to explain this whole thing. If they say, well, I've been reading about, and can you tell me? Well, that's a different story. But it's not necessary for us to say, we have, you know, oh, you won't believe what's happening in the industry right now, right? Why? You make them nervous, right? Go in there with confidence. There's a new option now to be a designated agent. This has caused a lot of confusion, okay? Designated agency is similar to dual agency in the sense that dual agency is when the broker represents both the seller and the buyer, or both the landlord and the tenant. It also means that everyone in the brokerage represents that seller and buyer or landlord and tenant. Which means if the two of you are in the same brokerage and you're representing the seller and you're representing the buyer, you can't help the seller negotiate. You can't help the buyer negotiate. Because you also represent the seller. So you can't give advice that would help the buyer get an advantage over the seller. Because now you're working against your client, even if you're not directly working with them. Everything you do in real estate is on behalf of your broker, right? So now the new designated agency allows two agents from the same brokerage to provide full fiduciary duties to that client. So now, if you are in the same brokerage, and this is all based on your broker's guidance, of course, but here's the guidance if you're with ours. If you are representing the seller, if you're representing the buyer, and you bring a buyer to the table, you already have the signed consent to designated agency signed. As part of the offer, you had it signed. Now, you can help the seller negotiate against EXP Realty's buyer, and vice versa. And that's what designated agency does. The broker still remains an impartial party to the contract. Okay? One of the questions that have come up, there's a lot of confusion. There's a lot of confusion. One of the things that have come up, a question was, can the broker be a designated agent for one party and work and represent them while one of their salespeople is a designated agent for the buyer? My answer, no. Because the broker has to be impartial. So how can they give advice to the seller while also being impartial to the buyer? It doesn't make any sense. I've heard things where people have said, oh yeah, that's fine. How? If you truly understand designated agency, it's not possible. There is a new CIS available. I understand it's, there was one distributed by the New Jersey Real Estate Commission. I understand that New Jersey Realtors updated zip forms, so now it's available there. Your brokerage may have some other platform that you use. So, you know, make sure you're using the updated CIS that says designated agency. Every one of your brokers probably always required you to have the CIS signed. It wasn't always a requirement by law to have it signed. Now it is a requirement to have it signed. And why did your broker make you have it signed if it wasn't a requirement? Because we're required to prove that we explain those relationships to that consumer. Okay? So that's why we always had it signed. Sometimes your brokers have good reasons for doing things, and it's usually to protect you. One note I will mention about designated agency: it is likely not a good option if you are part of a team. Okay? Why? Because the team leader is often involved with both clients, kind of like the broker, right? So when it comes to designated agency, typically one salesperson is designated as the designated agent, which means that other people within the team and within the brokerage, remember teams, you're not your own thing, right? You're still part of the brokerage, which means that you can't be part of that transaction, right? You can't be part of that transaction. So seller's agent, buyer's agent, disclosed dual agent is the best option for teams when multiple people are going to be involved, okay? We're going to talk about open houses. Well, I'm going to talk about open houses now. So when you're hosting an open house, as a designated agent, if you're only working as a designated agent, only you can host that open house. Because only you and your broker represent that seller or that landlord, okay? You want to always start as a seller's agent and disclosed dual agent or designated agent if the opportunity arises. This way, others in the brokerage can host the open house for you, okay? Others in the brokerage can host the open house or be there to help host the open house. One of the biggest changes that happened, which I was super excited about and was downplayed because I'm not sure everybody realized this. Did you know as a dual agent, the brokerage could not be compensated by both parties? Have you ever seen rental listings where it says compensation is split between landlord and broker? Please don't get me even started on compensation for rentals. But if the landlord and the tenant were represented by the same brokerage, only one party could pay that compensation. Did you know that? Couldn't split it. Now, or share it. So now, brokers can be compensated by both parties in a transaction, by the seller and buyer, by the landlord and tenant, if they represent both. And that applies both dual agency as well as designated agency. So that was a big thing because I know there are some brokers that didn't even know that, right? So I was glad that that change happened, okay? So I'm going to move to my next section, but if you have questions about sellers, just write them down, and then we'll do the Q&A at the end. So buyers and tenants. All references to, same thing, all references to compensation have been removed from the MLS. It's now going to be a conversation with the listing agent. Most importantly, it's now going to start with an agreement. You cannot show a property to a buyer or a tenant without a written agreement. There must be a written agreement, okay? And that has to be done at the start of the business relationship. That also includes the consumer information statement. That also includes a review of designated agency as well as dual agency. One of the pieces of advice I'll give you, based on the forms that were created by New Jersey Realtors, for buyers and tenants, there's, well, actually on all of them, there's a property address at the top, okay? You can have, I just had this question this morning, you can have a buyer or tenant sign those two forms at the start of the business relationship, but before you submit an offer, an address has to be included on that form, and you can't just write it in. Once an agreement is signed, it cannot be changed unless it's been initialed and dated by all parties. So my advice, if your broker tells you differently, follow their advice. Review those two forms, because you don't really need consent until it's time to discuss the property and to discuss placing an offer, okay? And then that would be a good time to sign it, okay? Some attorneys might agree with me, might disagree with me. Some brokers might disagree with me. That's fine. But that would be my advice for using those forms. That has to be in place. Sending listings to someone is not considered working with. It's about showing property, discussing the property, discussing prices, just like the CIS requires that to be signed, now specifically signed, prior to the discussion of motivation and price, right? So your best practice, always have it reviewed and signed. Same thing with compensation, can't be up to or no more than, okay? So please make sure that your compensation is exact. Compensation may not be increased after showing a property or submitting an offer. Cannot be increased, okay? You can always decrease the amount somebody can pay, okay? You can never charge them more, because it's okay to charge them less, right? We're always okay with being charged less. But we definitely want to have an agreement, something in writing, if you're going to try to charge me more, right? Same concept, okay? So, yes, sir?
Is that the buyer agent can't charge more, or the listing agent can't charge more?
Both. But well, it's specifically the buyer, but the listing, but it also applies to sellers. They can reduce their compensation. They can't increase it without consent from the seller.
So what I said was incorrect.
That
if you made an agreement, let's say the listing agent's like, all right, I'll pay you 2.5%, and then the buyer comes in with an offer. Buyer comes in, and they request the buyer compensation in their contract.
Right.
But when the seller signed the agreement with the listing agent, there's no buyer comp.
Right, so that's the sharing of compensation when it's in the listing agreement that way.
Oh,
so the new process now...
So it's not like the listing agent is going to get more money, it's just now the seller's willing to pay both.
Right, so, well, they will, but the different... And he's with the mortgage company, so that's why I'm answering his questions now, in case I said something wrong. The compensation now is going to be, instead of one to cover both, it's now going to be, this is my fee for representing you as a listing agent.
And that can't change.
That can go down. It can't go up without consent. Okay, and that was always the case, by the way.
I'll stop asking.
Yeah. Okay. So an important point here is that the compensation for a buyer can't be increased after you show a property or write an offer. Okay. There's some debate about whether it can be increased prior to that. And the answer is kind of yes, in the sense that before you show the property, the agreement can be amended if the compensation from the seller is, might be higher than what you agreed to. I'm going to advise against that because it really hurts the spirit of this entire process. This is about, you've hired me as your buyer's agent. This is the fee I charge, okay? We're no longer working for whatever we're getting, right? Now this is the fee we're charging. This is our fee. So it shouldn't change. If it has to decrease, that's a different story, but it should not be changed to match whatever the compensation is that is coming from a seller, okay? One of the things that we've been, I may have mentioned this, I talk about this so much, so sometimes I think I said something and I didn't. One of the pieces of advice that we've been giving to our sellers, I did say this, is not set a specific amount, right? Evaluate it as a term of the contract, okay? So have an idea based on what your net proceeds are, but evaluate it in the contract. Don't go out there and say, I'm offering this amount. Because guess what? This amount may be higher than what the buyer-broker agreement is for some of the brokers, right? So then, by what I just said about changing the agreement before showing, now you've cost the seller money, right? Because now they're going to end up paying compensation higher than what they originally might have if they had evaluated it as a term, okay? The compensation for a buyer or tenant can be paid by the seller or landlord. The request needs to go in the contract, and I'll give you examples of that. We're going to talk about those commission fields. I know it was just mentioned earlier about how great those are in the contract, and they are, but those are for reference only. So we'll come back to that. One of the biggest things has been about rental commissions, because some of you think that there's a standard rental commission in the industry, or at least in this state. I don't know why, okay? It is okay if by dumb luck your broker is charging the same thing as another one is. Federal antitrust is about those brokers or those agents talking together and saying, we're going to charge this specific amount. That's federal antitrust. But when I talk to agents in my brokerage and other brokerages, mostly other brokerages, there seems to be like a standard, right? There is none. And nobody say what it is, because I know it's all in your head. There's no standard. There isn't. There isn't. There never has been. There's no such thing as a standard commission. There can't be. All commissions are negotiable. So when you are taking a rental listing, if you have had rental listings where the tenant has compensated both brokers with whatever fee that was, that has to change. That has to change. You can't determine what a tenant broker is going to be paid. Right? Now the listing agreement is going to be whatever the listing fee is for listing that property with the landlord. And the tenants are going to have an agreement with their broker for representing them. Right? Whatever those amounts are. So now the tenant, in the same way a buyer can, the tenant can request, as part of the negotiation, that the landlord compensate their broker. At the same time, for those of you who are having difficulty with this, the landlord can request that whatever their fee is with their broker, they can request that the tenant pay it as part of the negotiation. But under no circumstances should there be an amount set by the listing broker that says split between. There never should have been. Never should have been. I'll come back to your question. Just write it down, okay? There never should have been, okay? So I've gotten some pushback on this, where I've said, well, landlords have never paid. Well, that's not true. Maybe when they're working with you. But why did a landlord think that they didn't have to pay a fee? You know why? Because you told them, and you told them, and you told them, and you told them. That's what, because somebody taught you that that was the way to do it. I was taught that was the way to do it. I didn't understand it at that time either. Okay? Kind of like the MLS fees. I didn't understand that then. I don't understand it now. You can't determine what a buyer broker or tenant broker is going to be compensated. And that's all part of this, right? So now landlords and tenants need written agreements, okay? If the landlord wants to request that the tenant compensate you as the listing broker, they can. That has to be part of the negotiation. It can't be you have to, okay? It has to be part of the negotiation. What else? Same thing, can't put MLS fees. The MLS listing fees. Again, this is going to be a continuous battle in our state, at least, because, again, it does not make sense for a seller to charge a listing fee or admin fee or other fee and deduct that from compensation that they're paying to a buyer broker. We talked about designated agency, again, not best for teams, and we can be now compensated by both parties. As a buyer's agent, you're going to need to change how you work with buyers. You're going to need to change how you work with buyers.